Hey friends, welcome back to my channel. May I ask that if you like the content, and even if you disagree with a little bit, may I ask you to subscribe, like, and comment below. But three of my favorite things are history, philosophy, and justice. We're going to knock out three birds with one video during a deep dive into John Rawls' theory of justice and try to explain it in a way that is easy to understand while examining five recent cases in the court system that I believe violated his theory and discuss Rawls' veil of ignorance. So let's go. Rawls, John Rawls is widely regarded as one of the most influential political philosophers of the 20th century. And his magna opus, his main work is A Theory of Justice, is considered a semi-work in the field of political philosophy, equality. When we think about justice, we often think about it in terms of fairness and equality. But the truth is, our societies are inherently unequal, and these inequalities can have a profound impact on our lives. From the moment we're born, our circumstances, such as our family background, race, socioeconomic status, can greatly influence our opportunities and outcomes. The challenge then is to create a system of justice that can account for these inequalities and ensure that everyone has a fair chance to succeed. This is precisely the problem that John Rawls aimed to tackle in his theory of justice. Inequalities can take many forms, from unequal access to education and health care to discriminatory laws, and social norms. These inequalities can lead to a lack of opportunities, social exclusion, and even poverty. The question is, how can we create a just society that addresses these inequalities and provides a fair shot of life for all individuals? Rawls' theory of justice often offers a framework for thinking about these issues and finding solutions. Rawls' theory is built upon two fundamental principles of justice. The first principle is what he called the equal basic liberties principle, which holds that every individual have should have the same basic rights and liberties, such as freedom of speech, freedom of assembly, and the right to vote, as well as other rights such as a fair and impartial trial, fair judge, and jury. This principle is based on the idea that these liberties are essential for human flourishing and that they should be equally available to all members of society. The second principle is the difference principle, which states that social and economic inequalities should be arranged so that they are the greatest benefit to the least advantaged members of society. The difference principle, which states that social and economic inequalities should be arranged so that they are the greatest benefit to the least advantaged members of society. Inequalities are only justifiable if they somehow benefit the most disadvantaged members of society. Rawls argued that these first principle should take priority before the second principle, and that the second principle should only come into play once the first principle has been satisfied. Now, is that an example of the justice system in America? Put your comments in the comment section below. Let's think about that. What does society think when they see teens or young adults, ages, say, 15 to 24? Uneducated, dumb, undeveloped brain. They have no or very little experience, might have bipolar or schizophrenia, anxiety, depression, or other mental health problems, maybe physical diagnosis. Society might say their kids, teenagers, are trying to find their identity, figure out who they are, and how to deal with their diagnosis. What is the big deal? They're kids, they're teens, their brain is maybe a little bit underdeveloped. Society also is thankful they are out of their teenage years. I mean, how many times does an adult say, I am so glad I'm done with teenage years, I do not want to go back? Why? Why do they feel that way? Tell me why you don't think you want to go back into your teenage years. Or if you're a teen, tell me about some of the struggles that you're going through. Because I don't want to call you out, but so that others can understand. We go back to that same thing. They are kids, teens, young adults. They don't know any better. What? Did I just say 15 to 24-year-olds have very little life experiences, or at least that is what society views it as? I would like to take a look at 5 sad, tragic, and very horrible cases in our judicial system. The first one, let's take a look at Ruby Franke and Jody Hildebrand. What about what their kids went through? What they did, the malnourishment. What if Ruby and Jody were never arrested? What if that kid never got out and went to someone else's house to get some help? And their 14 or 15-year-olds came up and rose up against them and brutally murdered them and killed them. Now, what would society want to do with that? Try them as adults. Lock them away forever. They are vicious monsters and they are evil. 2, let's take a look at the story of Sierra Hulseth. Now, she was signed a plea deal and she was offered a plea deal because she killed her father, Daniel Hulseth, with the help of her boyfriend, Aaron Guerrero. Daniel had a very popular YouTube channel, had a lot of followers. At sentencing, Sarah made some very harsh allegations against Daniel. Daniel's family, of course, denies it, but what I find interesting is that she claimed that she was abused, she was drugged, and there was a lot of things going on in the household. So what I find interesting is Daniel Hulseth started his YouTube channel, was joined in 2011, 2012, from what I've seen online, and when he joined YouTube. It also is interesting to me that Daniel was arrested with lewdness advancements against Sarah's mother in 2010, and they ended up getting divorced. 2011, 2012, a big custody battle issued, fighting for custody of Sarah, 2011, 2012, and started joining YouTube in 2011 and 2012. Is that a coincidence, or maybe not? Videos would, no question, show a great father. But what went on when the camera was off, when the camera wasn't rolling? Shortly after sentencing, I saw a video of Daniel posted on Facebook, a video that I am guessing Sarah was probably 6, 8 years old, dripping wet, wrapped in a towel. Now, what father would want to expose his 6 to 8-year-old daughter like that? Clearly, she just got out of the shower or a bath. Clearly, with the facial expression I saw on Sarah, that felt very uncomfortable. Now, seeing some of Daniel's past, is it a stretch to think that maybe Sarah was not making that stuff up at sentencing? Introduced her to porn, illustrating to his 13-year-old daughter that this is what men like, this is what real beauty is. Downgrading Sarah by, you're too young to have that type of opinion. Now, the crime these two committed was very terrible, very horrific, and I'm not trying to make excuses for them, but they stabbed him 70 times, burned him, dismembered him, stole his credit card, stole Daniel's car, fled to Utah. For what? The news said it was because Daniel didn't want Sarah and Aaron together. Really? Two teens with undeveloped brains are going to risk everything because Daniel doesn't want them together. Let us assume that everything Sarah claimed was 100% true. What if Sarah went to the police? My father is being very abusive to me. He's drugging me. He's doing all those things. They go to talk to Daniel. But I got a youth. Look at all these posts. Look at all. Is someone with thousands and thousands or maybe 1 million of followers gonna do this? What a huge following. Okay, that didn't work. Let me open up to my father's family. Surely they'll listen to their granddaughter. Oh, sweet Sierra, your father would never do that. Not my son. No, 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 no. So society is not only recognizing that teens are undeveloped brains and little to no life experiences, they also are pathological liars and can't be believed. I'm not excusing them for the horrific crime or calling out Daniel's family, but this is just such a violent crime. If you wanted to just kill Daniel, why not do that and just, why do everything else? That shows me how much hatred, anger, and resentment that Sarah had to her father that day and reached a breaking point. It also shows me that Sarah was searching for something when she met Aaron. Maybe love, appreciation, someone that cared for her, someone that tried to build her up. No. Society says that the two evil monsters and they I hope that they die in jail and they're not worthy of a second chance once they make parole or once they are eligible for parole if they make it. I can't do a video about this type of topic without also talking about a couple more teenagers, Carly Gregg and Cindy Powell, teens and adolescents that have disabilities, whether it be physical, mental, bipolar, or schizophrenia. Now, Cindy Powell's case is extremely interesting because she killed her mom by hitting her head on the head with a frying pan and stabbing her. Media report it was in an effort for her to hide the fact that she got kicked out of college. It is also reported she was a great high school student, very athletic. Seemed like the perfect student. What is something that teens fear? Letting the parents down, or letting their friends know that they are a failure, or having their friends think less of them, or something like that. They don't want their parents or friends to think less of them. This was a tragic and it was terrible. And I'm not trying to downgrade Sydney's actions or make light of Brenda Powell's death or anything. But the family, or let's call it like we will, the victims, went to the prosecutors and asked the prosecutors, don't prosecute Sydney, don't take her to trial. Why do you think that is? Maybe because they knew Sydney better than the state would know Sydney. All the state notices was the crime and the malicious act of Sidney Powell's actions. They don't know Sydney, and they don't know what her mental faculty. And to the state, everything that someone does is an intentional act in the eyes of the state prosecution. Mental health is just an excuse. Well, let's take a look at 4. What about Carly Gregg, 14-year-old? She killed her mom, Ashley, with a fully loaded armed firearm under the mattress. Now, The prosecutor said she is evil, she's a monstrous, and she's a demon child that killed her mom. After all, at 14 years old, having very little life experiences, right? Let's see her little to no experiences from what we've learned at trial and what we know. Her father was diagnosed and is bipolar. Carly witnessed her mom getting abused. Carly lost a sibling at 4 years old, showing signs of bipolar and schizophrenia. The father introduced her to beer at 12, blew marijuana in her face at a young age. But she is just a child with an undeveloped brain and mental issues and on the wrong medication. Try her as an adult and lock her away for the rest of her life. Wait a minute. Society views her as a teen, but it is ethical it is ethical to try her as an adult. So on one hand, they have an undeveloped brain, they don't know consequences for their actions, they may be abused, they may have all this stuff going on, but we don't care about that. They should still know right from wrong and be tried as an adult. Prosecutors tried to get her to enter a 40-year plea deal to plead guilty for murder, and they dropped the tampering and the attempted murder on her father. Is any teen going to agree to that? I have more thoughts, and check out other videos in my library of the Carly Gregg trial and with my opinions. I also have started a group to help try and get justice for Carly Greggs and win her freedom back for due to her mental faculties. And also, I will put in the link that there is a campaign going around by the victims. Let's call it what it will. It's actually the family members of that Carly Gregg, but the victims trying to raise money to support her appeal. How many teens, 15 to 20, get nervous or intimidated by police who try to bully them or submit their authority or show their power over them by avoiding reading their Miranda rights to get a confession? But, well, then the confession can get thrown out of court and they can't use it against her. Well, let's look at the fifth case. A year ago, I watched the trial of Megan Amerowitz. And I'm not trying to call out attention to this because it was a very emotional trial, I'm sure, for Megan, but played an interaction with police because she was a suspect for domestic violence at the time. Now, a couple months later, after this domestic violence, her father died, and she was then charged with the murder of her father. If Megan comes across this, I'm not trying to bring up the traumatic experiences of the past, but I just want to share what I saw. Now, if I was on that jury, I am trying to visualize the events, from the testimony, trying to fit bits and pieces together. During the trial, doctors testified that this was a possible assault and called the police. When the police arrived at the hospital, doctors told the police that the father told him, meaning the doctor, Megan assaulted him and did this to him. Austin, her brother, testified and said his father told Megan that he did this. The police interviewed the father in the burn, and all the father said was that we have mutual disagreements at times, and we get into arguments. She yells at me, I yell at her. So kind of like a mutual argument thing. And then he gave the police to enter the house and do a further investigation. Now the father, they found a white powder that was identified as lye powder that severely burned her father. Now, I am not a lawyer, but I watch a lot of lawyer channels, and learn Miranda only needs to be implemented if they are in custody and interrogation. But to make an arrest and put them in custody, they need suspicion that someone committed a crime and that Megan committed it. So now what does the police have right now? Well, they have a man with severe burns. They have a white powder at the scene. 3 people that said Megan attacked them. Sounds like suspicious activity that a crime was committed and Megan committed it. Why didn't they just go pick her up at the hotel or wherever she was and place her under arrest? Oh, wait a minute. They would have had to read Megan her Miranda warning. She would have she would have been able to request a lawyer, and she would know that she was a suspect. But when the police comes, they're just talking to you, and the police don't know what, or the suspect doesn't know what you know. They don't know they're a suspect. And they would have probably been very difficult to get any type of confession, even though Megan never admitted throwing live powder. In my opinion, the police interview should have never been admitted because, in my opinion, the police and the prosecutors violated Megan's constitutional basic rights, and liberties were violated according to Rawls' first principle. If I was on that jury, I wouldn't have considered any type of confession because I think police and detectives try to get confessions as a means to make their job easier. Now, feel free to disagree and leave your comments in the comment section below. Megan was charged and convicted of unlawful possession of an irritant causing death, even though the prosecution didn't ever link the live powder physically to Megan's hands. They didn't present any evidence of her purchasing it, testimony of a friend that allowed her to borrow it, or even got from it online. Which is kind of funny because Austin testified that he knew that everything that was in the house, everything his father owned. And Megan and her father were the only occupants, but he didn't seem to recognize the white powder as there prior, but to just say that it was there, that's the white powder that was at the scene. Austin also testified that he was there the night before. What's my point? Well, if Austin knew all the chemicals, like he testified that his father possessed, and identified the white powder but didn't acknowledge it was there the night before, either Austin was telling the truth or he was over exaggerating the truth and he didn't really know what his father had in his cabinets, making his testimony, in my opinion, not credible and unreliable for the truth of the matter if Megan was guilty and if she did have unlawful possession of this irritant in the first place. Megan, to give us circumstantial evidence, like I said, that she had unlawful possession of this irritant, there should have been some video or surveillance of her buying it. Maybe a browser history on the phone, or buying it, or texting asking a friend to borrow it. Prosecutors didn't show anything like that in that case. The live powder didn't magically appear in the house, and according to Austin, he knew everything his father had, and never testified the lie was in the house the night before. The equal basics liberties principle is a cornerstone of Rawls' theory, and it's easy to see why, without basic liberties, individuals are unable to participate fully in society, express themselves, or even advocate for their own interest. By ensuing that these basic liberties are equally available to all, we can create a more level playing field and promote greater cohesion The difference principle, on the other hand, is more of a Rawls argued that society, social and economic inequalities can actually be beneficial for society as a whole, but only if they lead to greater benefits for the least advantaged. For example, a society might allow for income inequalities if it leads to greater economic growth, which in turn benefit the poor and marginalized. However, this is only justifiable if the benefits are indeed distributed fairly and do not exacerbate existing inequalities. Beyond reasonable doubt is supposed to be based on common sense and reason. Okay, let's look at some other facts that have happened more recently. Larry Smith was a Detroit man when he was 18 was convicted of first-degree murder from in a 1994 fatal shooting, based in part on the testimony of an informant. Now 48, he was released in 2021 after his life in prison without the possibility of parole conviction was overturned. Devontae Sanford, who was 14 years old and convicted of a quadruple murder, was given a $7.5 million settlement for his wrongful conviction. Gary Washington, then 25, was accused of fatally shooting a 17-year-old during a drug dispute in East Baltimore. No physical evidence was found at the scene, and other than the bullet that killed the 17-year-old, and a gun was never recovered. In 2018, a judge vindicated Washington's conviction. The witness recanted his testimony, saying police manipulated him into identifying Washington as the shooter. Washington's 1987 conviction in Baltimore City hinged on the testimony of a 12-year-old boy. So not only can police be very intimidating and detectives be very intimidating when they talk to teenagers, but they can also manipulate, just tell them this is what you saw. He was sentenced to life in prison plus an additional 20 years to run concurrently. And finally, that got overturned. Ever remember the Mike Tyson Evander Holyfield match when Mike Tyson bit off Holyfield's ear? John McLean and Eduardo Dumbridge, 18 and 15, were watching this fight, and they were convicted of a murder that happened. And while they were doing their time, the killer actually confessed while in prison from another charge, and their conviction was overturned. Christine Lobato was given 40 to 100 years for first-degree murder for killing a homeless man, and exonerated in 2017, filed for compensation for the Las Vegas Police Department in 2019, and nothing has yet been settled. I'm sure it took them, 4 or 5 years and stuff to slap on the handcuffs once the jury read that guilty verdict. Now, what do all these cases have to do in common with the cases that I mentioned previously? Everybody was between the ages of 14 and 25. Conclusion: the judicial system is biased against young adults, teens, particularly with mental health and emotional problems. Society wants to hold these people accountable and get the conviction by any means necessary. Rawls' theory relies heavily on the concept of the original position and what he calls the veil of ignorance. The original position is a thought experiment in which individuals come together to decide on principles of justice that will govern their future society. Now, let's take a look at a lot of these people that have been convicted, and when they were convicted, they thought that they were monsters, and all the hate that is going on with Carly Gregg right now. Let's put all those people in a room to figure out the just society. And they're supposed to think of every single uh, being, every single step, every single law, every single situation, every single gender, everything. Now, once all the laws have been signed, everybody in that era drops dead. But they immediately come to life in the society that they just fought. The problem is they don't know what position they will have in society. Maybe they're born into wealth. Maybe they're born into poor. Maybe they come back as a woman and they signed a law that would say that women are secondhand citizens. Maybe they're a woman and born into, a man. Or like some of these cases we discussed today, maybe they're given a chance at life in an abusive relationship, abusive father, maybe a given bipolar or schizophrenia. And then they have to deal with the very things that they're dealing with right now. The veil of ignorance is a means to ensure that individuals make decisions based on fairness and justice rather than self-interest. By putting themselves in the shoes of others, individuals are more likely to choose principles that are fair and just for all members of society. In the original position, individuals are free to propose and discuss different principles of justice, and they will eventually settle on the principles that they think are the most just. Rawls argued that under these conditions, individuals will choose his two principles of justice as they provide the fairest and most just outcomes for all members of society. The veil of ignorance is a crucial component of this thought experiment, as it forces individuals to think about justice from a more objective perspective rather than from a self-interested one, by imagining themselves in the other's shoes. Individuals can develop a greater sense of empathy and understanding, and they can begin to see the world from different perspectives. Today, Rawls' theory of justice remains highly relevant, offering a framework for thinking about justice and inequalities in our own societies by understanding his principles of justice and the thought experiments that underpin them. We can gain a deeper appreciation for the complexities of justice and the challenges of creating a more just society. So, how would Rawls define a just society? Is America based on Rawls' two principles of just society? Put your comments in the comment section below. And make sure you like, subscribe, click that bell notification for future videos. Thanks for watching, and if you have any other interested in learning more about political theories or philosophers, make sure you click that bell notification, and I will see you on the next one.
Don't you worry about a thing. You get what you're given, but it's never too late to spread your wings.